Jack, can you do it?
Let me try again. Did it work?
Yep.
Oh, awesome. All right. No, actually what I was going to do, and I don't know what y'all talked about while I was in flux there in IT purgatory, which I'm in often. I absolutely was agreeing with what both Dorothy and Sydney were saying, but one of the things I was going to ask about, just being ignorant on this piece, and I think you were touching on it, the level of advocacy that goes on in one of these cases, and I was wondering specifically from the point of view of the advocate who's assigned to be, or the attorney who's assigned to be the advocate for the juvenile. It seems to me that a lot of the issues here turn on the question of whether or not you get dual capacity. You can fulfill your role as an advocate and fulfill your role as a witness. In this case, as Dorothy pointed out, the sole witness, the person who has all the information, oftentimes related to what is going to be the fulcrum information that turns this case. But I guess my question, as I said, is the advocate for the juvenile. Could you help us? Because so I'm just in my head, I'm picturing civil superior court, because that's where I practice. So I see a judge, I see a couple tables, and I see kind of a mid table with someone maybe representing the juvenile's interest. And now there are two people sitting there. There's a GAL and there's the attorney advocate for the child. And at the two main tables, you've got dad's attorney, mom's attorney, or whoever's, and those attorneys are want to get someone on the stand to start drilling down on the information that can give the court the opportunity to know what's going to be in the best interest of the child. So I guess my question is the problem that when the attorney representing the juvenile is acting as an advocate, do they themselves typically, would they be cross-examining a witness? For example, the GAL, who went around and interviewed all the different parties?
Yes.
Wow. Then, I mean, I heard what Gina, what you were saying about the cost to our some of our rural counties, but the cost to justice is pretty high here too, right?
Absolutely.
Right. To the point that Dorothy and Sydney are making, I mean, a parent's lawyer has got a constitutional right to confront all of the information that is being put into evidence about why his or her client should lose the right to be a parent. I mean, you know, and it's all either criminal or quasi-criminal, or you wouldn't be in a TPR setting to begin with. So precluding a parent's lawyer from going after whoever gets on the witness stand is just simply unconstitutional.
Okay, I absolutely agree. So going then back to Nicole's question to us a few minutes ago, which is, can we develop this thing in a way that says, yes, because absent that information in the courtroom, it's a hardship. Well, it's a hardship to everybody. It's a hardship to all parties, but that hardship would also include a hardship to the attorney representing or the advocate representing the juvenile. And so that's why we're thinking in this case, we can fit it into an exception.
Jack, I think the only hardship is finances. I mean, there are some rural counties that don't have as many attorneys who could play, like who could be the role and take over the role of the guardian ad litem, but most of them have a handful where, and also in some of the rural counties, they meet once a month and they have a handful of attorneys that rotate through, and they don't have as many private termination of parental rights actions. That's just the nature of their courtroom, right? So if you take away the personnel issue, it's a financial issue. And the reason why I say that is because the guardian ad litem program for the state in DSS cases where DSS is involved, not these private termination of parental rights hearings we're talking about, but just the regular program is set up and it has an attorney representing the kids. And then it also has a volunteer. There are some instances, which Reggie can speak to, where there are some counties where you do have the dual role of the attorney advocate for their conflict attorneys who do the dual role of witness and attorney advocate. And that will be a cost to the state and to taxpayers because they are in that dual role. Like Johnston County has a dual role attorney, advocate, and conflict attorney, and he has 45 cases. And I have a trial with him on Wednesday, and he's going to have to testify and put his report in. And this is what happens in many courtrooms across the state. So this is going to be a huge shift. My point is I'm not denying that it would be a huge shift. I'm just saying that I think we should do it the way that it should be properly done, which is having the role that we have in most of our cases where you have a volunteer and then you have an attorney. Because I think that that's what justice, I think that's what families deserve. I think that's what kids deserve. And I think that at least from the professional code of ethics, I think that's why Nicole wrote it the first way wrote it the way that she wrote it in the first place.
Yeah. Right. Thank you, Sydney. That was very helpful. Thank you.
I agree 100%, which is why I started off with, why are we even talking about? I mean,
but I feel like I'm sorry, Dorothy, but I do feel like I'm probably beating a dead horse. When I read the first opinion, I feel like it's saying the way it's written, it seems like there's just a lot of room where you could submit a report and say, well, I'm submitting the report and I don't think that I'm going to be I'm going to be asked to testify. So here's my report. And then you get into the trouble that was that was reported in the RD case, which is where the judge asks the GAL to testify. The GAL says, no, I can't. And then the side of the case that's sort of against what the GAL is saying in the report says, well, no, you better testify because I've got a lot of things to tell you or to ask you about. And then the judge says, no, you're off the hook. You can, as if it's a solution to the person who wants to cross-examine them. Well, they can either submit their report and withdraw, or, submit their report and not testify, or they can withdraw and testify. And I think that was a little backward because it was really impacting the rights of the petitioner at that point, who wanted to be able to cross-examine.
So I thought I read this as the number one is, if I'm looking at the correct one, inquiry one and opinion one is when you are purely appointed as the GAL, not the attorney advocate. So you can submit the report then and try not to become a necessary, being careful not to become a necessary witness. But then inquiry two is under Rule 3.7, is it permitted for the attorney to call him or herself as a witness? No. And then 3, can the conflict attorney who drafted the GAL report be called as a witness by a court or another party? And that's where it gets into the right.
But I'm thinking on inquiry 1 where it says, may the attorney file a court report, we're saying yes, if they feel like that they aren't going to become a witness.
But that's when the attorney is appointed in a purely GAL role. That attorney is not serving as the GAL attorney.
Yes.
Right. So they're just being a regular old GAL that we were talking about in that particular instance.
So that would be assuming that there would be a GAL advocate as a separate person would be a GAL advocate. But then why would that even?
What do you think about defining the term? Because I see what you're saying, Dion, and we all abuse, well, I don't know what y'all do, but in Mecklenburg County, everybody in district court abuses the terminology guardian ad litem. It means a bunch of different things. So maybe if we were to define the term in opinion 1, that might help. I think also the language, be careful not to become a necessary witness. We might have to tell people how you do that. Because, a lot of people who are doing this work may not understand that if they put a certain thing in their report, Johnny told me X, and therefore I say Y, well, we get to cross-examine you about what Johnny told you. So the people doing the work may not know how to avoid becoming an unnecessary witness. We may have to tell them how to do that.
See, I
But-
think
but
that
Gina,
part
thi-
about avoiding becoming a necessary witness is, I don't know if we should even include that at all. Because how can a person avoid becoming a necessary witness? They don't get to make the determination as to whether or not they're a necessary witness.
Exactly. And I think by telling people what can and cannot go in the report, probably.
But then that takes them out of doing what they were supposed to do as the guardian ad litem,
Yeah.
to do a
Yeah,
full
if-
investigation. You get what I'm saying?
Yeah, and just to follow that up, I mean, and that's the whole purpose of the GAL, right? To be the neutral, objective, we're collecting the information. And if they presuppose while they're collecting the information or before they collect the information, I better not ask these questions because it might give me too much information. So then I would become a necessary witness. Then they're not going to ask the right questions, right?
Mhm.
And just the way that I'm reading it, I mean, if someone is purely a GAL, they don't have to worry about becoming a necessary witness because they aren't doing the advocacy piece of it. So
Exactly.
I
Yeah.
don't
No,
think,
I think in that instance, they don't have to worry about becoming one. They should automatically assume they are one. Is
right,
what I'm saying.
right.
Right.
So I think that answering the question for the attorney, that the pure GAL is going to get you, sure, file the report, be a witness, do both. I don't think you're limited on either way. But if you are the GAL advocate, I don't think you can do a report or be a witness.
And Dion, what I recall is that we got in the weeds with regards to just in that first meeting. And so Nicole drafted this and then we were all saying what you just said. And then she goes, it seems like we're going to have to stop. So we didn't even get a full chance to vet her first opinion. Because I think that if that's the direction we're going to, we have to address some of those questions. But what I recall is that it was fundamentally, we were talking about the difference between just saying, yeah, there are two different roles, stay in your lane and make that very clear. Or are we going to look at the Supreme Court opinion and try and make that fit into, a square peg into a round hole, frankly, is the equivalent of what I think that opinion tries to do. I mean, I can't tell Supreme Court anything. I'm not on it. And they tell us what to do all the time. But regardless, professional rules of conduct or something, right? Our ethics are very different than what anybody tells us in that regard. I will say and point out to you guys that 7B601, which is the statute that deals with appointments of guardian ad litems, doesn't necessarily mean that you have to appoint, unless Reggie or Dorothy can tell me otherwise, the appointment of a guardian ad litem attorney advocate. It references an attorney advocate, but all it says is that you appoint a guardian ad litem.
Mhm.
So a judge could just appoint a guardian ad litem, never appoint an attorney advocate.
Exactly.
And then that person testifies and prepares a cross-examination, and I'm only a role of a GAL volunteer and not of an attorney. And I can't wear both hats. I just choose to testify. And because we're attorneys, and the only way in those courtrooms and private court cases, they're attorneys that are appointed. They're not volunteers from the guardian ad litem program that the state runs. They're attorneys that typically will represent parents and do conflict cases.
I totally agree. And that's exactly what happens in child support cases when a guardian ad litem is appointed. It is just a guardian ad litem that's appointed. So the attorney that's serving in that role, they're just a guardian ad litem. They don't then ask for an attorney, a GAL attorney advocate on top of the GAL too. So it'd be very much just like those. Now, of course, the parents are paying for that guardian ad litem, but that's what
Sydney,
it is.
I have a question for Sydney. Sydney, did you say 7B601? Is that the statute you just referenced?
Yeah, 7B601 is the appointment and duties of a guardian ad litem. But in the TPR statute, there's another statute that you referenced, which is the appointment when a parent files an answer or it's a contested hearing, the court shall appoint a guardian ad litem. The guardian ad litem appointment at that point is pursuant to 601. So whatever obligations that it just relates back to 601. So there are two statutes that we should be looking at. Does that make sense?
Okay, so what was the second one?
The second one, I will have to go right back to. It gives the court in private, well, it gives the court in termination hearings the right, the mandate to actually appoint a GAL. I'll get that to you. I know Reggie wants to talk, so I'll look it up and then let you know, Nicole.
Okay, because 601 says that if a GAL is a non-lawyer, then the court shall appoint a lawyer as the advocate.
Yes, and what I was saying, and in our cases, they only appoint attorneys because the only attorneys that are ever in that courtroom to take private cases are attorneys. They're not volunteers off the street, right?
Okay.
Like they have to be licensed attorneys to even get appointed in private termination of parental rights hearings.
It's 1108 for the TPR one.
Thanks, Dorothy.
Mhm.
Reggie, did you have something?
Yes, thank you. Thank you for letting me speak. I wanted to be sure that it was appropriate for me to speak, so thank you. I was going to just respond to the statement that was just made, and Ms. McLaughlin, I think did say what I was going to say, which is it does say that the way I read 601 is it says that if the court is going to appoint only one person to represent the child, it does need to be an attorney, and that attorney can fill those dual roles. So that's what, and I think Ms. Batch cleared that up also, but I just wanted to make sure that was that was clear. And I've noticed that that the discussion seems to be centering around TPRs and terminations of parental rights, which is only a fraction of what happens in A&D court. Not that changes the committee's opinion, but you know, that's the majority of cases aren't going to go to TPR. The majority of cases are going to be the underlying A&D action. And this situation presents itself in those cases also. And I think there's also, this happens in private cases too. Typically in private cases, we're only looking at the termination of parental rights phase. But in cases where the Department of Social Services is involved, those are not private cases. And in the instances that what led to this question is generally situations where the guardian line of program has been conflicted out of representation. So, and sometimes it's the program is not involved in some of these cases. Now, in the underlying case, there are instances where we have attorney only representation in the A&D case. I wanted to just raise a point. One of the reasons why I wanted the subcommittee to consider NRA-RD is because the initial opinion, there's this conflict with NRA-RD and what was initially proffered. And I understand that there can be differences of opinion, but since there are two bodies that have concurrent authority here, and so it's theoretically possible that the bar could come up with an opinion, and under 84-36, the court could come up with another opinion, which is sort of what happened in a sense. I mean, in a sense, the Supreme Court one could argue, is using its authority not only to rule on the matter, but its authority under 84-36 the trial court was using its authority under 84-36, and then the Supreme Court was reviewing that to see if there was an abuse of discretion. So my concern with not somehow incorporating, or the question maybe with not incorporating or mentioning NRA-RD, is that there's going to be potentially this significant conflict between RD and some opinion. And so I don't know if that's worth the subcommittee wrestling with that or considering that, but I thought it would be important to mention that.
So now I'm really.
I'll go out on the limb and say with that, I see that as if we do issue this opinion without referencing that case, then that should be more guidance to them moving forward if they have these questions come before them as a court, because we will have defined more what the different roles are and how they're to be undertaken. So, because they didn't have that before, you know what I mean? Not when that case and opinion was issued. So I'll go out on the limb and say that. But as Sydney said, we we don't get to tell them necessarily what to do, but
can I say, Brian told me I don't have to do it. Right, Brian? I'm pretty sure that that's what I can say, and they won't care. District court judges will say, that's cool. Brian said it was fine. Sydney, you don't have to testify. But I do think that's a legitimate concern that we have, which is we can tell them that it's, we're not going to violate, so long as we can use the cover of the judge and we don't get a bar complaint that you guys then will say, hey, by the way, we're going to censure you. I think that's the reality, right? To Reggie's point, you got two different bodies who govern what we're doing. I just will say, though, I stand by my opinion that I don't think that we should try and go out of our way and bend over backwards to create an exception that is truly financial.
right, I agree with that.
I think that's where we go down a path, in my opinion, which is really problematic. Now, if we do that, that's fine. The attorney takes the stand and the attorney gets cross-examined like we've been doing for eons. So I think it needs to be like, I don't think that we should walk away from this with having an opinion that says a report is okay and you can't cross-examine. I think it's either the attorney is the advocate and is also the volunteer and gets to be on the hot seat, as we are all the time. Dorothy and I have been at guardian ad litems on a regular basis and cross-examined by all the parties, including the judge. So that's the case, and that's fine. I still think that we should have two people, but if we go down that path, I just don't think that we should go down the path of you can put a report in and that this expectations that no one should be able to cross-examine. I think that's really problematic.
Yeah.
And one more thing to Reggie's point about this issue, not only cropping up in termination proceedings. Remember, it also crops up in domestic court and contested custody cases. And one of the things that I'm concerned about, at least in Mecklenburg County, we have an organization that appoints two people. The Council for Children's Rights appoints a lawyer, volunteer, guardian ad litem, and then a lay person called a custody advocate. And it's the lay person who actually talks to the children and the teachers. And then the guardian ad litem lawyer calls the lay person custody advocate as a witness. But in a lot of times when the Council for Children's Rights gets overwhelmed, which is all the time, judges start appointing one private lawyer to do this work. And I'm concerned if we make it clear that it always has to be two people, that judges are simply going to stop appointing people to this vital role, and courts in custody cases are not going to get the good quality evidence that they get when they have a guardian ad litem to be able to present it. So, I mean, maybe that's just tough, unsolvable problem, but I just thought I would raise it.
So I heard you say in private custody cases, am I hearing you correctly to say in those private custody cases, they're getting appointed guardian ad litems and a guardian ad litem advocate?
Yes.
I've
Yeah.
never heard that.
Yes, but it's only in Mecklenburg because we've got gobs of money and an organization called the Council for Children's
Right,
Rights
I'm
that does this
very
work.
familiar with them. So what I described before was what I'm used to, which is in a regular custody case, the judge, the parties, once somebody raises or makes a motion that a guardian ad litem should be appointed. And then the judge appoints a guardian ad litem who is an attorney, but they're only serving as the guardian ad litem. And then they're paid by the two parents. The guardian ad litem is paid for their services by the two parents. But I've never seen a case where an attorney advocate represent, because I've been appointed as a guardian ad litem plenty of times in custody cases. And I've never had an attorney advocate representing me and doing all the crossing. Now, as the guardian ad litem, I've had to testify every time, but I've never served as the advocate where I'm cross-examining people and all of that either. So
Yeah,
that's why I was likening that to, what I've described before as to what could happen in the custody case. I didn't realize that actually happened somewhere.
Yeah, and it's really the perfect model. The problem is it requires funding and manpower that most counties outside of Mecklenburg and Wake are not going to have the ability to do.
Well, I don't think that we need to work. I mean, because this isn't covering that, is it? This opinion does not cover those private custody cases.
That's right.
So,
But I keep bringing it up because I think the next thing we're going to hear about, and I know I'm supposed to just focus on what we're focusing on, but I think the next thing we're going to hear about is how does this apply to that scenario?
Well, I think you all are an exception to the rule that in those custody cases, because I've never heard of that before. So I guess you'll have to keep it a secret from your people in Mexico. That's what I'm saying.
Good thing this isn't being live streamed, Dorothy.
Oh, sorry.
No, no.
I miss Dorothy so much. I miss you, Dorothy.
So guys, it's getting close to 3 o'clock, but I didn't know if we want to continue to talk or if we need to recess and come back, but I don't know. I guess we can start summarizing where we are or how much further down the road we've gotten.
I'm gonna mute my.
I mean, does everyone have 10 more minutes? Okay.
Yes.
So, so I think what we're hearing is we don't like option 2 or option 3. Is that what I'm hearing? At least.
From me, yes. Sorry, Nicole, as she stayed up all night trying to
I was
make
gonna
it
say,
work
she
for
did
us.
all this work.
Exceptionally well written, though.
Sorry.
I liked your first one, just for the record. I was good with your first one with a
Me
few
too.
tweaks.
No problem. That's my job to, give you what you need so you can make an informed decision.
And then, so does anyone have anything to say in favor of parts or pieces of the second and third one before we go back to the first one and talk some about that? I mean, do we mention, as Reggie had sort of suggested, do we need to at least mention that we know that NRA RD is out there, or do we just not even entertain that there may be a conflict? I guess while we're thinking about that, on the first opinion, am I the only person who has problems with giving any space for I mean, given any space for a report? If we're saying, I mean, I don't think there is a problem if you're just a pure GAL. You can write a report and testify all day long. The problem would be if you were a GAL advocate. And then is there any space for a report?
Reggie had his hand up, but to your point, Dion, I think that it does need to be clarified. Like if you're just in that role, if we're going to go by the letter of the like our ethical standards, then yeah, we do need to make it clear. You can't do both. You got to pick a lane and establish that early and then decide. And what the judges have been doing now in Wake County, since this was brought to their attention, unhappily by me, they're not happy with me. But what they have done is they have basically said, what role do you want, Sydney? In one of my cases, I'm now the attorney advocate. The other, I had already done all of the legwork as the volunteer and talked to 6 different witnesses and the child. So they kept me in my volunteer role. And now I've got an attorney representing me in the upcoming trial. So I think we do need to be very clear that it's not both. It's you pick, and it should be determined probably in the appointment order as to what people's role is.
So, and just to follow that up real quick, I know Reggie had his hand up, and so I know you're next, Reggie, but just quickly to follow up on Sydney's point there, the earlier the better, finding our lanes. One of the things we talked about early on was the issue of the way in which, if you're appointed an advocate versus if you're appointed a neutral third party who's objectively seeking all information relevant, right? Like if I am seeking information as an advocate, I'm constantly in my mind trimming, pruning, hedging, spinning, to create a narrative for my side. And so your point, Sydney, it made me think again about what we talked about. I think maybe the first or second meeting, which was if this person does not know their role when they start the process of interviewing. I mean, just from the very beginning, it's going to shape the way they do their job. And if my job is an advocate and I start interviewing people with the idea of an advocate, but then all these other people in court are going to expect me to present an objective report. Going back to your what you said 10 minutes ago, how is justice going to be found that way? But I'm sorry, Reggie, you had your hand up.
No, thank you. Thank you very much. I wanted to just, along the lines of what Ms. Fortner just kind of brought up, is to say that a couple things. One, to the extent different jurisdictions, there are many, obviously jurisdictions are very different across the state in the number of attorneys that they have to pull from for this and to do A&D work. And they're very different in their approaches to permanency planning review and termination of criminal rights hearings. So to the earlier line of discussion about maybe I want to defend, if you will, people's opinion that maybe they would not see themselves as a necessary witness in certain instances, because that's just the practice in their jurisdiction to not, at the permanency planning review stage, they're just not as high conflict as, say, some of our more larger urban or suburban jurisdictions. So I wanted just to acknowledge that, or to just put that out there. And I do think, I hope the subcommittee will consider that very many, and it was said earlier, but many bars are very limited in the number of attorneys that they have doing this work. And I think that there needs to be, I understand that there's not wanting to be considerate about the financial burden, and I understand that point. And I don't know that, in all candor, I don't know the financial burden, because we're talking about many different groups and pots of money. So, or potentially, at least potentially two. But the fact is that many jurisdictions have such limited resources that should maybe be a thought in what this looks like. And also, I can understand the position that termination of criminal rights is inherently adversarial. That makes sense. Permanency plannings can be, and they don't have to be, but they certainly can be. And they can be at any stage in the permanency planning hearing. They can start out not adversarial and end up very adversarial. So I think the committee also needs to understand that at any given moment, I think this is maybe was said earlier, that a person, the guardian ad litem, could be called as a witness. It's not like they're witness lists. There's not like, it's much more fluid. And I guess I'll just leave it at those points. I appreciate you once again letting me present it and raise some of the issues and raise some of the concerns. So thanks a lot.
I'll just add that I don't disagree with Reggie with regards to the personnel issue in different counties, but what I will say is that there are certain times in which you don't shortcut what we're doing. And if there weren't enough parent attorneys to represent parents in court, you got to figure it out, because that's just what the law requires. And I just don't think that it is in our best interest for the families that are going through this process to decide that because we have an imperfect system, which frankly, it's hard to get court people to work for it's hard to find attorneys to work for $55 an hour, right? I mean, this is an easily solved issue. It just takes money. But again, I don't know that we should then look at that and say, we're going to make an exception to what our ethical code and responsibility should be with regards to professional conduct in a courtroom, because there's only 10 people in 2 counties that could potentially fill this role. I just think that's a dangerous precedent to set for us to try and figure out how we navigate that. And I think that, to Nicole's point, she said that there was an exception. The only thing that she could say, and she was doing her research, which said financial reasons are not an exception to the exception in opinion 3. And I think that tells us a lot of what we should be looking at. So, I mean, I'm not trying to be insensitive to other counties and to those issues, but I do think that it's really important for us to take into serious consideration what's actually best in our judicial system and for the families that go through it, rather than we don't have enough attorneys. That's another problem that needs to be solved in our, frankly, justice system that's not working so great in the juvenile space.
So I have a question for Sydney and Dorothy. So if you're in court and there's one lawyer, say you're the only lawyer that's been appointed to the child. So you are serving both the guardian ad litem role and the attorney advocate role. So the purpose of Rule 3.7 is to avoid confusing the trier of fact about what the lawyer's role is. So my question to you is, when all of this is happening in court and you're called to testify, is there any confusion about who you are and what you're doing?
No, but I
And
do
this
think
is
it,
just a judge hearing, right? I mean, this is
Yeah.
not a jury.
the judge knows we're wearing two hats. And I think the question is how you wear that hat, to Jack's point. Am I looking at it from an objective? I'm collecting all my evidence, but now I know that my 8-year-old client wants their rights terminated and we're a best interest state. So what information do I provide?
And I could very well present the evidence or the information in a way that I'm being clear as to which role I'm in, but then someone else starts to cross-examine me to show that I'm not serving in that particular role and in that way. And if I would have, I'm usually on that side, being that attorney to cross-examine the person to do that. So.
Well,
And can
also,
I say a little bit more to Reggie's point, because everything that Sydney said, like she said before, we probably agree on everything that we would say. But I was going to try to be quiet and thought we would go to another meeting to talk about all of that. But I agree with everything. But I also want to ask the question, because I wasn't here for the first meeting. What actually goes into the decision or the final resolution that there is a conflict on the part of the guardian ad litem program? I never got that information, because I don't know what analysis they go through to determine that there is a conflict in order to kick it out. Is it the kind of analysis that we do as lawyers? And you know what I mean? Like, what is that analysis?
Reggie, maybe you can speak to that, because I don't, that information wasn't provided to me to put into the opinion. The only facts that I had was that the GAL program had a conflict.
Okay. And I have a follow-up question once I hear that.
So the guardian ad litem has a policy, a conflicts policy that is based on the rules of professional conduct, but it also incorporates the idea that our volunteers and the program could have a conflict, and the rules of professional conduct don't deal with non-attorneys' conduct. So if, for example, one child is alleged to have perpetrated on another child, we typically view that as a conflict of interest for the attorney advocate to represent both children. So we would have a conflict attorney appointed in a situation like that. If we previously represented the child and that child is now a parent in an A&D proceeding, we would view that as a conflict. Things, those are typical things that we run into where there would be a conflict, and we would notify the court and provide the court with a possible resolution and get the court's authority to move forward with how that conflict was going to be resolved.
Okay. And I asked that question, one, because I just wanted to know, and I just see all that there is a conflict, and I didn't know what actually went into play on how you all determine the conflict. So one part of what I was going to say is that a way to keep it from being an issue for us as far as funding and personnel and all of that is for the guardian ad litem program to reconsider what constitutes a conflict on you all's end, because you all do have the money to be able to, serve all these kids in this way in both roles. So, and I mean, that'll help with that funding side. At the same time too, I forgot what I was, that. I'll leave it at that. Oh, that's what I was gonna say. I don't see it being a conflict as often. Like we don't have like the guardian ad litem program conflicts that happen. At the way we're talking about it is we're talking about it as if it happens so frequently that is, it's this big old situation that happens all the time when it's not that way. I mean, at least from my experience, it's not. I mean, I know you know better than me, Reggie, because you know probably across the state, but I know in my experience, it's not like 50% of the cases that we have in court is a conflict case for the guardian ad litem program. So you're like trying to figure out who can be appointed, and you're looking for all these people, going back to Sydney's point about we have to look and search for parent attorney. Right now in Durham, we have a shortage of parents attorneys right now, but they figure it out and get attorneys appointed.
So Dorothy, I apologize, guys. I'm not the expert here. Nicole is the one that's been drafting this opinion. You all are the subject matter experts. But what you just said, Dorothy, kind of hit something of just figuring it out that I think maybe could become a part or just some sort of thought in this opinion. This opinion, it has the potential to, I think, as previously discussed, impact the way that these cases are handled across the state. But it's also one of those things where you do have a judge involved. And I guess it occurs to me that, the courts have concurrent jurisdiction over matters of professional responsibility with the state bar. And so while we can offer what we think is the best answer under the rules of professional conduct, I think the opinion could also acknowledge this fact and could acknowledge that courts, perhaps in appointing someone, particularly in these smaller communities that don't have the funding, that courts are effectively, I look for a better term, but blessing this situation if they have to appoint somebody to serve in this dual role, that they may very well be aware of the conflict, of the tension that's presented to the lawyer. But regardless of what the state bar thinks, the state bar has one answer and what the ideal is, but that a court could, even in light of that consideration, still appoint somebody and recognize in the interest of judicial efficiency and in the interest of justice that this just may be the best way to deal with it. And we could kind of recognize that, put the opinion, put the state bar in, not in the role where we are trying to legislate and dictate to everybody how they're supposed to do their business, but this is our guidance and we offer to you for your consideration. And so maybe that could be a part that would allow then some flexibility for the different districts that just have a different situation altogether.
So if we do that, then I'm not sure that a published FEO is the best way to do that, to issue this opinion, and maybe it should be private, because then it sounds like we're carving out an exception to violate the rule.
Yeah, I mean, I see exactly what you're saying. I think we have an old published opinion about the Attorney General's office. The Attorney General's office has an abundance of conflicts potentially, especially if different divisions are at odds with each other. And, we have to navigate that because they are statutorily required to represent those different departments. And there's no real way around that other than imposing upon them the financial burden of hiring outside counsel. So it's not necessarily unprecedented, although it certainly isn't something that we're trying to do one day after another. But I guess it's also, I don't know, in some ways, I'm also thinking of the times that I've advised folks who are in the middle of a criminal case, and they're trying to get out. They are presented with a very clear conflict, and they should withdraw right then, right there. And the judge just says, nope, figure it out. And that's something where we can state the ideal, we can state what the rules say, but the court is also supervising this entire thing. And so I guess, I don't know, I'm trying to think of a way to resolve this issue where I think it seems like there's a fair consensus of what the answer should be, but knowing that what the answer should be may not be practical, particularly in certain jurisdictions or certain districts. And that's the, kind of part of the hang up. So that's why I just wanted to offer that thought and, do with it what you feel appropriate.
Brian, I will just interject really quickly and say that this is one of the most appealed areas of law to the Court of Appeals and the Supreme Court. They get hundreds of appeals. So whatever may happen, and maybe they say, well, we already decided on this, it's not going to be an appealable issue, or it's not reversible error. But I do think that if you go down that path, every single jurisdiction deals with their juvenile cases very differently. And you're going to have a variety of, you'll have one judge who says, well, the report comes in, nobody testifies, you can't cross-examine. You'll have another judge who says, oh yeah, you can do a dual role. You'll have another judge that appoints 2 people at all times. And you're going to, out of 100 counties, probably have 20 different ways that they do it on a regular basis. And also depending on which attorneys are in front of them. So I think, to Nicole's point, I have no earthly idea the direction or whether you publish it or not, but I do think that if anything else, if you're going to be an attorney like myself or other attorneys who do a lot of guardian ad litem work, I need to have cover to know that I'm not violating the professional, my professional ethics and the professional code if we're going to go down that road. And if the judge gives me cover and you guys say good, then when I get a bar complaint from another attorney, then great. I'll just say, Judge, Smith said it was okay. But I do think that that's a concern for some of us who actually are in the courtroom all the time and are handling these cases. And what I've asked the judges to do is appoint me another attorney because I agree with opinion 1. But if we give guidance, so there's something else that comes about, I just want to make sure that we're giving cover to the vast majority of attorneys who really are doing a lot for very little money and helping a court system and children that I really enjoy representing kids. But you will probably have less of us doing it if it's not very clear as to whether or not we're going to have some form of cover if we're going to open ourselves up to a bar complaint, just being honest.
I think that's a very fair point. And at the very least, you can point people to this video on YouTube and say, listen to what Brian said. It's his fault.
Brian said I can't get in trouble. So again.
No, that's a really good point. Especially, so does this ever serve as grounds for appeal? Like appointing somebody in this dual role and they say that was somehow prejudicial to the overall proceeding?
As an appellate attorney, Dorothy and I look for opportunities to always find things that we can appeal to try and see whether or not the court, and sometimes case to first impression, or depends if the Court of Appeals, which panel you get. Now that all of the decisions are going back to the Court of Appeals before they go back to the Supreme Court, there's going to be varying opinions like we had before, unfortunately. So, but yes, to answer your question, Dorothy and I look for opportunities to bring up challenges to things to help our clients and advocate for them.
Well, does anyone have any, where should we go from here, I guess? Do we start looking at the first opinion and see what we like and don't like, or do we like it just the way that it is? Do we need to just go ahead and set another meeting with some goals in mind with what we're going to speak about?
Option 3.
Okay. Then what do you think we should be looking at for the next meeting, Dorothy? Putting you on the spot.
The 3 different ones. I already have a strong opinion about the 3, but at least giving people more time to look at those 3 and then coming back to the table to discuss those and where we should go from there.
Okay, Nicole, what are you feeling? What are you thinking?
So based on the discussion that we're having, I thought we were going to nix opinions 2 and 3 all together, and we're going to.
Oh, well, I'm fine with that. I was hoping that was the case, but I wasn't sure. So y'all got a better sense of things than I do.
So I think that's what we do. We focus on number 1 and make tweaks or adjustments to that as we see fit. I've taken, of course, lots of notes. So I can go back through and maybe just clarify some things, maybe in opinion number 1, where the question is about the lawyer who is appointed as just a GAL, and take out all of the language about the lawyer then serving as a witness, and then jump to number 2, which then will incorporate, can if the lawyer is appointed as the guardian ad litem and the attorney advocate, then can they call themselves a witness? Can they be cross-examined and then go from there? So
Yes.
we were headed. I can also incorporate what Brian's comments were. And I do agree with him on that, the courts have concurrent jurisdiction. And I was looking for the ethics opinion that we talked about in our very first meeting. Must be 2012 FEO 9. And that's the opinion that says that, if the lawyer's not clear on what their role is, then you need to ask the judge. But that opinion is very narrowly tailored to whatever that subject was and does not include what we're talking about here. So I would have to incorporate language where I can incorporate that same language and we're just going to apply it to this, to an and case as opposed to, I'm sorry, but I don't remember what what the facts of that opinion is. It's been a while since I looked at it. So why don't I just start making some adjustments to the opinion and I will send it back to all of you. If we are going to have another meeting, we need to do it fast. So within the next 2 weeks, we need to have another meeting so that we're ready for the October meeting. I have other subcommittees that I have to do as well. So does that sound like a plan? I mean, if we can get, Sydney, are you going to be available in the next 2 weeks? Is your legislature stuff done right now?
Yeah, no, we're going to be there till November, but I do still have Mondays and Fridays,
Okay.
Thursday afternoons. It's pretty consistent. So if we could just put it in there, or if we really do have to squeeze it in, I'll move something around and make sure
Okay.
that I'm available.
Okay. So does that sound like a plan?
Yes, that sounds great. So
Okay.
I guess we can adjourn now and we will look forward to seeing the tweaks. I think that the main thing that I've said it now probably too much, but just, trying to make sure in that the heartburn I had was in that first inquiry and getting some confusion about whether or not, if you're the attorney advocate, could you ever write a report? I mean, and do we ever give that possibility? And I don't know, it sounded like sometimes when Reggie was speaking that maybe there were some times that the attorney advocate would know that they could write a report and they wouldn't be a witness, but I can't see it.
Okay.
But anyway, okay, anybody else have anything? Thank you very much for your service.
Thank you, everyone. And Lenise will be in touch soon with a poll so we can pick another meeting date.
All
Thanks,
Okay.
Nicole. Thanks for writing all
Thank you so
that.
much, Nicole.
Yes.
Thank you, Nicole.